How was your session, Michael? Welcome everyone to the session on internet rules. On day three, it's really good for us to get started with heavy, but not so heavy discussions on how the internet is regulated and how our freedoms online are regulated. Um, what motivated us to do this session is the fact that in the last couple of years, especially around the pandemic, multiple ICT legislation have been enacted in the region, no? Especially South and Southeast Asia. Similarly, key jurisprudence orders from courts have also emerged in the region, shedding greater light on how the internet can be regulated, how we may or may not exercise our rights in the online spaces. The session that we put together is also timely because APC, in collaboration with SafeNet, had just completed a week-long intensive training with 24 individuals just last week from Southeast Asia. The training was called Internet Rules, and it was on ICT law and legislation. Michael was one of the faculty, um, as well as Damar was also another faculty at the workshop last week. ICT legislation in the region, um, I would say in some cases, have provided the much needed clarity in certain circumstances, and in certain other circumstances, they have become a method of legalization of illegitimate restrictions. It is also important for us to note that these ICT laws do not function or are not enacted in a vacuum. There is a tendency to draw inspiration, borrow from, or even outright copy from countries in the region within this jurisdiction. Um, APC has over the years been putting together different kind of resources that helps us understand and analyze these laws better. For instance, we had worked on a collaborative called the Cyrilla Collaborative to put together a database on ICT laws and legislation, cases, regulation from the region. It's a searchable database, so it's quite helpful. Besides that, we've been putting together comprehensive tables that map the ICT laws in South Asia and Southeast Asia. We've been predominantly using these sort of documents, the tables that map ICT laws for our capacity building exercises. But also over time, these tables have allowed us to see what the trend has been across regions, what are the similarities and dissimilarities between countries within the sub-regions. We've also started writing on jurisprudence that shapes digital rights in the region. We came out with one publication last year on how courts in South Asia are thinking around digital rights. And we're really hopeful that maybe this year we'll get to do an edition on Southeast Asia. So if any of you are interested in pitching in or leading the work on putting together different pieces of jurisprudence of how courts are thinking in Southeast Asia, please do get in touch with us. We would really appreciate that. But there is just a lot of resources out there on how ICT legislation have been coming up in the region. But what is really interesting is how are these ICT legislation being enacted? Is it multi-stakeholder enough? Are we happy with the consultations? Or do we fully understand the impact of these ICT legislation? Or the greater question is, do the drafters of these laws know the impact of this legislation, right? So what we have we've done, or what we were hoping in putting this panel together, is to further that discussion, is to bring together experts from the region to look at ICT laws, to see whether there are good laws, whether they've been developed in an inclusive manner, and to see how these good laws can improve the trust in the internet, and how certain undesirable instances or legislation may impact the trust on the internet. So let me go ahead and introduce this fantastic panel to you. We'll start with Michael Castor. Michael, maybe we can quickly wave, who is the Asia Digital Program Manager at Article 19. Prior to joining Article 19, much of Michael's work focused on freedom of association, human rights in China and Southeast Asia, and on the situation of human rights defenders. We are also joined by Gayatri Venkateswaran, who is an assistant professor at the School of Media, Languages and Cultures, Faculty of Arts and Social Sciences at the University of Nottingham, Malaysia. She is an author and former executive director of Southeast Asian Press Alliance and a member and a close partner of APC. Apar Gupta is the executive director of Internet Freedom Foundation, an Indian digital liberties organization that seeks to ensure that technology respects fundamental rights. Prior to this, Apar was a commercial litigator. He's currently supporting or engaged in many developments surrounding digital rights litigation and regulation. Damar Huniarto is a prominent human rights activist who is known for his work on digital rights and online freedoms of expression in Southeast Asian region. He is the executive director of Southeast Asia Freedom of Expression Network, SafeNet, a regional organization that focuses on promoting and protecting digital rights in Southeast Asian countries. What we will be hearing from the panelists, who will be each taking about 6 to 7 minutes to share their experiences with us, is to hear the developments in the region, their concerns around the developments, the different perspectives around the developments, either in their countries or more broadly in the region. Specifically, I think we'll be hearing about India, Indonesia, and Malaysia specific instances, but Michael will also be talking about the broader region and important developments in the region. Beyond reflecting on the issues in the region, the speakers will also be talking about the change they would like to see, the concrete movements they would like to see. So with no further delay, let me hand it over to Michael first to ask him about the developments in the region and why they are concerning from a human rights perspective. Over to you, Michael.
Thank you very much. So I would like to start, maybe someone's, if you could all be muted, someone's speaking in the back there. Thank you. So I would like to start actually with a quick reminder of exactly what it is that international human rights law says about the freedom of expression and the permissible restrictions on the freedom of expression. I think this was an important lens in which we can view all of the regional laws and policies that we will be discussing. So, of course, as we all likely know, Article 19 of the Universal Declaration on Human Rights and the International Covenant on Civil and Political Rights establishes the right to freedom of expression, access to information, and the freedom to form and hold opinions. And while this is a fundamental right, it's not necessarily absolute. Under strict circumstances, states may limit the freedom of expression, but these restrictions must adhere to what is known as the three-part test. In other words, they must be provided for by law and formulated with sufficient precision so that any individual may regulate their conduct accordingly, so that any vague or overbroad restrictions are simply never permissible. Two, they must be in pursuit of a legitimate aim. And these legitimate aims are laid out also in Article 19 and elsewhere. For example, they include to respect or protect other rights, or in the name of national security, whereby the Syracuse principles and others provide further clarity on the permissible restrictions to the freedom of expression in the name of national security. And three, they must be necessary and proportionate. Again, in other words, they may not be vague or overbroad, and in particular, they should be specific and tailored and the least intrusive means available. The UN Human Rights Committee has been clear also that any limitations to the freedom of expression or access to information on the internet must adhere to the same three-part test as applied to the freedom of expression offline. And so with that framework in mind, I'd like to sort of provide a little bit of an overview of some of the trends in laws and policies that we have seen in the region. And in particular, in the last year and a half, in the name of combating or dealing with the COVID-19 pandemic, we've seen a raft of really abusive laws and policies whose rationale has been to deal with, among other things, the spreading of false information or causing fear under COVID. We saw this in particular in Malaysia in March with the shameless repackaging of the previously repealed anti-fake news law in the form of the emergency ordinance number 2, which again abjectly fails the above mentioned three-part test. And Gayatri will tell us a bit more about this in particular in her section. But it's not only been in Malaysia. Governments in Thailand and elsewhere have also cranked up so-called anti-fake news centers or pushed legislation that, in the case of Thailand, has gone after combating the spreading of fear online, regardless of the veracity of that content. Thankfully, this, known as Regulation 29, was revoked by the Prime Minister shortly after it was enacted, actually, but only following an injunction by the civil court, again, in response to pressure from civil society. And attendant with this is, of course, the backtracking on privacy rights. At the same time, in China or Cambodia, either the drafting or passing of personal information or personal data protection laws, we've seen large loopholes carved out for exceptions for national security, which leaves people's personal or private information very much at risk. At the same time, in Thailand also, the personal data protection law, which was set to take force, go into force 2 years ago, was postponed till last year, and again has been postponed until next year. As flawed as it might be, is actually really a needed protection against now what we see as the overreach of surveillance of collecting and controlling online information under the new ministerial regulation under the Computer Crimes Act in Thailand, which took effect in August. Across the region, we are also seeing a really serious assault on intermediary liability principles. Governments are pushing a strict liability model, which is already in use, for example, in Thailand and China. In countries like India and Indonesia, ratcheting up content regulation and holding intermediaries more accountable for what is produced by others. In Malaysia, the state has gone after independent media like Malaysia Kini for what third-party comments have been left on news articles. And just recently, earlier this month, the Australian High Court quite shockingly passed a law that will hold media companies responsible for what third parties write on the comments to their social media posts. Of course, this raises the risk for self-censorship and leads to a number of other concerns for the freedom of expression online. And again, are very questionable under the three-part test. The international principles are also clear under the Manila Principles that generally intermediaries should not be held accountable for what third parties post, which is why some of these laws are so concerning. Apar will tell us more about some of this in India. Part of the push for stricter intermediary liability, we also see this trend for data localization or the registration or local contact person designation written into laws and other internet governance regulations. This has been discussed. This is being discussed now in Thailand. It's been written into Indonesia's Ministerial Regulation 5 and also in Vietnam's very concerning cybersecurity law. Data localization in this sense is really concerning, not only because it means local citizens are at risk of their personal or private information falling into the hands of local authorities, where it used to presumably be stored in servers in other countries, where the authorities would have to go through a mutual law enforcement agreement, treaty, or other judicial process to access it, is now able to access it locally. But also the designation of a local contact person puts that individual at risk of financial or criminal or imprisonment in the face of, again, these vague or overbroad or often arbitrary regulations. As with other restrictions on the freedom of expression, this requirement for local registration is also considered a restriction on the freedom of expression, and under international law, likewise must adhere to the three-part test. And now, because my time is short, I'll just mention one final trend that we see across the region of controlling access to information online through censorship laws, forcing multinational companies or platforms or local telcos or ISPs, for example, to follow whitelists or blacklists. We see this in Cambodia with in the beginning of this year, the passage of the sub-decree establishing a national internet gateway. And of course, following the coup, the Tatmadaw in Myanmar pursued this both through the telecommunications law and through extrajudicial means. And in Indonesia, in particular, we've seen the government sort of weaponizing full-scale internet shutdowns, as we'll hear more about, of course, from Damar. And in closing, I would like to just point that the solution is to all of these problems is obviously country and context specific and much more complicated than a simple snapshot or soundbite. But the foundation, the starting point must be an adherence to international human rights norms. And if anything else, the beginning of any restrictions on the freedom of expression online, of course, must begin from a standpoint of whether or not they adhere to the three-part test. Thank you.
Michael, and also the example that you talked about points out the critical role that courts play, right, in terms of ensuring that laws remain on the book or not. And in some cases, the jurisprudence can also be problematic, as you point out in the case of Australia. So it's a really interesting point that you brought up in terms of the role of courts. That actually is a great sort of segue to Gaia. Gaia, could you be able to talk to us more about Malaysia, more specifically about the emergency ordinance on fake news? How has it impacted media and the general exercise of digital rights?
Thank you, Gaia. And I think for those who are in our list, good morning, and you'll see these two Gaias here. We always make jokes and have fun about this. So if you're going to raise a question, please do specify, because we tend to speak for each other.
Yeah, but I just want to be very clear that I'm the other Gaia. That's what you're saying, but other Gaia, that's probably.
Thanks for the invitation. And it really is a good, sort of to speak after Michael. And I particularly like when he used the word shameless when describing the Malaysian reincarnation of the Anti-Fake News Act. I would use the word impunity, the way in which authorities and our legislators have actually enacted laws in Malaysia is with the impunity because of the total absence of any kind of consultation. So earlier when Gaia was mentioning about the processes of lawmaking and also the sort of legislative framework, very obvious in Malaysia that it misses, or it doesn't have the kind of consultations, broad consultations, meaningful consultations. And so none of what Michael had mentioned as far as, the standards that one should adhere to is present in any of these laws that affect freedom of expression and also to the media. I do want to focus on the emergency ordinance and just looking at it from I have 3 points. One is the law itself. But talking about it, maybe taking us back a few years before the ordinance was actually passed this year, some of the cases that were actually brought to court under this ordinance, and also the question of the media, because I think that in the context of Malaysia, one has to look at the impact, not necessarily directly, because we have a state that has 60 years of experience and knowing how to intimidate different segments of the population and silence them using different tools. So let me start with the law. And I wanted to say that the emergency ordinance, as Michael pointed out, was actually from the Anti-Fake News Act, which was passed in 2018 and then eventually repealed in 2019. It is word by word with a few additional texts. But it came from basically 2014. I would say its genesis was 2014, starting with the amendment to the Evidence Act to make intermediaries liable because of the increased number of people using social media, posting comments on blogs, on news websites, and they needed a much more convenient way of gathering evidence because existing ones under the Criminal Procedure Code, under the Communications and Multimedia Act, which have been there from 1998, pose much more burden on the investigators and the authorities. And so actually when the Communications and Multimedia Act were in force from 1998, Very little in terms of content regulation. A lot of it were more infrastructure based, which was what it should be, and what it should be really focused on. But it was after 2015 that we saw a spike in cases being filed under the Communications and Multimedia Act for content violation, to annoy, to cause harm, the most broadly, the most vague definitions we've seen. So there was an increase, and this is also coincidental with the scandal involving the former Prime Minister, the 1MDB scandal, for some of you who may be familiar. So that was the peak of that kind of attack. And so that was the context in which there was also a plan to actually amend the Communications Multimedia Act to make content regulation a lot more stricter, and to impose a lot more penalties, and to make investigations easier for the authorities. So that was the background. Come 2018 was the general elections. It was a party that was facing a lot of a challenge. And so the Anti-Fake News Act came in thanks to some wonderful experts from the North who have introduced this idea of Anti-Fake News Act. So it was actually with foreign consultants and for governments that like to tell CSOs, you are, allowing foreign interference. This is a classic case of foreign interference into our local national issues. Yeah. So the law was passed just before the elections to prevent any questioning, any use of the reference to the 1MDB in campaigns and by the media. So very significantly, when we were doing monitoring of the media, very little reference to the 1MDB as a critical discussion. The only references were the positive aspects of 1MDB. And so, you had immediate, instant impact actually from that law. Anyway, repealed because the new government came into place. And so when the pandemic happened and we had a political coup, and so I think we have to look at the emergency ordinance that affected content also within the context of the coup, the political coup. So the inclusion or the addition to what was in the Anti-Fake News Act was to add the word COVID-19. Yeah, that was the only among the few words that they added to kind of narrow the focus of the ordinance to say any content that was considered fake, false in relation to COVID-19 and the government's actions towards addressing the COVID. So that was that. But like many other laws that we have commented on in the past and analyzed, it's again very broadly defined. There's absolutely no burden on the prosecution to demonstrate what exactly the harms are or were, because it's tied to public order, public safety. No demonstration of any of those things, and the burden is solely on those who are charged, defendants. And in many cases, actually, we see that, and I think this is an important one. So I go to the next one, which are the cases that have come under the emergency ordinance. We've had the first case. So the ordinance was passed and made effective in March. The first instances where cases were documented from April and then subsequently in May. And these are what I would say as the ordinary folks. They are not influencers, they are not politicians, they are not the media. These are people who would typically be responding to issues at a very, I would say, in a very legitimate, even if it's ill-informed. I think these are concerns by the public that are then expressed. And I would say that the way to address them is actually to provide more information. So the ones who were first charged under this ordinance, first is a housewife. So she doesn't work. She has children. She was pregnant. She shared a post on WhatsApp together, sent it out, of a school that had an outbreak of pandemic. And she has school-going children, okay? Now, if you look at the surrounding issues, there were many schools in many states in the country that had recorded cases of children, pupils, actually suffering from, who tested positive for COVID. So it is not out of context. It is not alarmist because it's an ongoing issue. It is a very, very real concern. Now, all of this, of course, never factored in the hearing because she pleaded guilty. And this is what happens to a lot of people who come under the Communications Multimedia Act. And we've seen now in emergency ordinance is that they're either unrepresented and often they plead guilty, yeah, because they don't want the case to drag and they there's appeal on the grounds of first time offenders and humanitarian grounds and all that. And so she pleaded guilty, so that's the first case, and the second one is a teacher who posted a photo of a police officer who was down on the floor with two colleagues with the statement, this police officer had his vaccine and he had a heart attack, and so the vaccine has adverse effects. Again, surrounding issues are concerns regarding the safety of the vaccine, which is a legitimate issue. I mean, we can debate about vaccines, but that's a separate issue, yeah? It is a legitimate concern, especially in an environment where we have very mixed reactions about vaccine on various grounds, yeah? It's not 100%, yay, let's all go vaccine. We know in many societies that there are vaccine hesitants, anti-vaxxers, or those who are questioning on the grounds of the way it is administered. So, they're legitimate grounds. So that's the second one. A 50-year-old teacher, again, not one you would consider to have, 20,000 on TikTok or 2 million followers. He's someone who uses these platforms to share his expression and opinion. The police came out to say that it was not because of vaccine, and that should have sufficed. That should have sufficed and stopped the case. But it was brought to court. Again, he pleaded guilty, and that was the second one. Third one, another case of a woman who talked about the vaccine again, questioning the safety of the vaccine, and shared a video or a picture of someone who said this guy has information about the dangers and the risks of vaccine. That was it. That was the post. So these are the three cases. So occurred, or at least documented, between April and May. Cases came to court in September. So this is the basis of the cases. Again, courts did not demand for an explanation or submission by the prosecution to say where is the harm, except to say that, oh yeah, if you say this is not true, therefore I, as a judge at the Sessions Court, have accepted that these are not true, these are false. Yeah. In an ongoing environment where people are debating, medical professionals are debating a lot of these aspects of the pandemic, you cannot, impose such heavy penalties on people who don't deal with medical issues on a daily basis. And so judges and courts have not demanded for the basis of the harm, the arguments, and have, just meted out the sentences. Under the Anti-Fake News Act, there was one case. Again, the judge made it very, very clear that she was not going to ask the prosecution for the basis of the falsehood or the fake news in that case. So what we are seeing is that courts are accepting the prosecution's arguments as the arbiters of truth, for the lack of a better way of explaining it. And so that is not being debated at all in that sense. So the third one is really, what is the impact overall? And with the media, I would say that actually the impact on the media is not so much directly through the emergency ordinance, but through all the slew of acts that we have. But what it does through the emergency ordinance is create a sense of fear among sources of information in speaking to the media. So that's an indirect impact. But at the same time, they're using the Sedition Act, they're using Communications Multimedia Act, Penal Code to investigate and harass media personnel and workers who conduct their work, on a day-to-day basis. So that goes on, while here the focus is on citizens, individuals who are sharing information to create that kind of wariness. Yeah. And so I would say that in combination, then you have a situation where people are afraid, but not for the right reason. It's not that it stops the spread of information, because I'm involved in fact-checking as well. So contrary to what the minister and the government says, there's no reduction in fake news, false news, because the definition of false and fake is already problematic from the authorities. So what we see is, an attempt to just cut down criticism of government, procedures, practices during this lockdown. So maybe that I'll stop there just to sort of, cap it. And happy to take on questions and also what I see the way forward, so to speak. Yeah. Thanks.
Sorry to cut that short, Gaia, but I'm sure we'll come back to questions. I already see a couple of questions about the anti-fake news law, whether there's a time limit on it, etc. Right? So we'll talk about that in just a bit. Let me go to apart from that, right? To hear about the developments in India, specifically the regulatory and jurisprudential developments. If you look at the chat, for instance, there's a lot of comments about the important role of intermediary, though they might be problematic in their own ways, but still they have an important role to play, right? And then there's also reference to this new phenomenon of pushing legislation to pushing regulation through during the COVID pandemic period. So, Apar, could you possibly take that question on as well? This phenomena of pushing legislation through, and what are the key developments in India, in your opinion?
Thank you so much, Gaia. And drawing from the excellent comments which were provided earlier, I'll attempt to structure my initial comments with respect to what have been regulatory as well as legal developments impacting digital rights in India and over the course of the past 2 years. Your introduction is correct to a large extent that the pandemic has provided an opportunity to the government in India to restrict free expression as well as undermine privacy through certain regulatory pronouncements, which have changed the larger environment of compliance for intermediaries, but has also operationalized certain practices, which has also increased surveillance, which is important for me to indicate as well. In terms of the broad developments, I will be dealing with the increase in internet shutdowns, which is also being litigated during the course of the pandemic, the intermediaries rules, and with respect to surveillance, I will be looking at attempts to undermine end-to-end encryption to further surveillance, as well as certain movements towards operationalizing mass surveillance programs without underlying legal backings. So we also need to understand through this panel that quite often certain operational practices which threaten digital rights, especially in India, may not be arising clearly from legality by itself, which is the first ingredient of the three-part test. Thereby, it will lack a specified purpose and will not contain adequate safeguards by itself. Thereby, any such measure which is quite often implemented may not be captured in the regulatory prism, but its effect is far more severe in threatening user rights by itself. Very quickly running through this list, firstly, with respect to internet shutdowns, the regulatory power with respect to this is contained under the Telegraph Act, and the Telegraph Act essentially is a colonial enactment which is also shared with several other countries across Southeast Asia, as well as in the Africas. So African nations. So if you look at the Telegraph Act, it vests exclusive control ownership within the political executive of that country and permits in certain provisions untrammeled and unrestricted power for interfering with the course of transmission of messages, which will also include surveillance, but will also include preventing their transmission itself, such as through internet shutdowns. About 3 years ago, certain regulatory processes were defined through the process of rules, which would be a form of subordinate legislation. However, these rules did not contain adequate safeguards and were criticized. These rules, it is important to note, were not put to public consultation. Thereafter, we have seen a noticeable incidence in the rise of internet shutdowns, whereby these rules, rather than providing a level of safeguard, regulation, have in fact operationalized a practice of internet shutdowns. The most recent one, which we have witnessed in Rajasthan, which has been a statewide internet shutdown on the reason of preventing cheating in certain entrance examinations organized by the state government for certain public services relating to policing itself. However, the litigation with respect to this, which was also a very important part, as pointed out by Gaia, has resulted in a certain level of incremental transparency, where now any internet shutdown order, if it is made, needs to be transparently disclosed. However, compliance with this direction, in the case of Anuradha Bhasin versus Union of India, which was in the context of the telecommunication shutdown in the former state of Jammu and Kashmir, is something which essentially has resulted in some element of and enabled some form of remedy for civil society. Now, very quickly, being mindful of time, stepping towards the intermediaries rules, which has been the big regulatory development. The intermediaries rules are not an independent form of legislation, but flow from Section 79, which is the safe harbor provision providing intermediaries exemption from liability for user-generated content under the Information Technology Act. This has again been commented upon and litigated in the 2015 decision of the Supreme Court in Shreya Singhal versus Union of India. In this decision, the court noted that there is a requirement for a notification of by a court or by a public authority to constitute actual knowledge for a takedown to be effectuated, and for the intermediaries' obligations in terms of maintaining its exemption from liability to be maintained. However, the intermediaries rules changed this drastically. Firstly, the rules in its scope, even though it is subordinate legislation which cannot go beyond the scope of Section 79, also have Part 3, which now has introduced regulation through subordinate legislation, which is impermissible with respect to digital news media platforms, which provide a high degree of independent journalistic output, quite often critical of government policies or even of public officials. So the form of regulation invests ministerial level oversight, which may also include blocking of certain web pages, specific web pages, as well as the websites itself. Also enforces a form of registration for any person engaged in news publication in a systematic level, leading to any kind of business activity. The rules also in Part 3 regulate now and bring the SIM system with respect to online video curated platforms such as Netflix, Amazon Prime, Hulu, etc., Hotstar, Disney, which are there in India. It is my belief that this is also because that cinema has traditionally been very restricted in terms of its permissiveness on comment on contemporary issues of society, culture, and politics. And this space was being explored by OTT providers. There are several petitions with respect to the intermediaries rules right now pending in the high courts in India. And Part 3, which does relate to news portals, has been criticized by courts and has at present been stayed. So it cannot be enforced against news portals. Very quickly, summing up on this, I would like to say the intermediaries rules with respect to Part 2 undermine user rights substantially by attacking intermediaries. And in fact, if one looks at the only sliver of user right which is recognized, which is the transparency, which is the complaint process to an intermediary, the necessity for intermediaries to respond, and the disclosure through a monthly transparency report, all of these portions by themselves are incomplete. If you look at it much more closely, and this is where I would invite a greater look, a closer look. For instance, the transparency requirement is only with respect to user reports, not with respect to government requests. So we never get the picture with respect to what is actually happening. With this, I would like to pause at this moment. Thank you so much.
Thank you, Appa. Thank you for that. That actually is the beginning part of your intervention, as actually very neatly connects to Damar's interventions. Damar, we are running out of a little bit of time, but it's fine. We should be able to take questions as we go, so it should be all right. Damar, can you talk to us about the court order around internet shutdowns? Any other significant developments in Indonesia?
Yeah, thank you, Gaya. Good morning for everyone who attend this session. I will quickly share what happened in Indonesia, especially related with the topics on some regulatories and action related to the freedom of expression and also the right to access. I will share the Indonesian experience, because if we remember 2 years ago in 2019, there were blanket internet shutdown in Papua and West Papua that happening almost 3 months, and then this become big issues in Indonesia, since this is the most repressive action coming from the government in the name of preventing hoaxes. Although the real reason behind it is to control the information during the peace protests against racism for Papuan people. So 3 months after the internet shutdown, we SafeNet and IG, the Alliance of Independent Journalists, file a lawsuit to Jakarta Administrative Court because we want to challenge this action due to the we believe there is no legal basis. If I try to quote what Michael said about the 3-part test, we analyzed the situation and then we found out that there must be something wrong with this action because there is no legal basis. Although the government said that it based on the existing IT law, especially in Article 40. So when we went to the administrative court, and then the judges on June 2020 decide that they agree with us, they agree with the plaintiff that this government action of blocking data services and terminating internet access in Papua province and West Papua province were an unlawful act. So we are thinking, the civil society in Indonesia, we are thinking that this is the end of the internet shutdown in Indonesia. But the thing is, after that, in 2020 and until 2021, this year, we keep on receiving internet outage from Papua. Although this one is not a blanket internet shutdown, this one is specific on a small area, especially in an armed conflict area between the Indonesian army and then the people from Papua who have a conflict with the army, and then we saw that this is actually still implemented in Papua. That's why we are thinking that we have to challenge this again, not only challenge the internet shutdown, but challenge the source of this action that focus on the Article 40 of the IAT law, which is the Article 40 give the excessive power, excessive authority for the government to terminate access. So we go together now. Aji and also Arnold Belau is asked the Constitutional Court. We went to the Constitutional Court. We want the Constitutional Court to declare that this Article 40.2b is unconstitutional, then ask the government right now to require to issue a state administrative decree before exercising its authority to terminate access. Because without that, we keep on having the alleged internet shutdown in Papua. So the court is already actually all the session is already there. We are now waiting for the decision from the Constitutional Court. Supposed to be next month on October. We are hoping that the Constitutional Court will declare this article is unconstitutional. That then we can ask the government to do issuing the state administrative decree before implementing the intermittent access. But the issue is not only here, because the issue is internet shutdown is if the internet shutdown, internet access is coming from the government, right? But there is a new threat where this is cross with the intermediate reliability, because right now the government try through the Minister Regulation number 5, or we simplified is into MR5. The new threat is, what if the government then using the intermediary to do the terminate to terminate the access through Article 13 and Article 15 inside the MR5. Actually, they can do that right now, because by doing this, actually, when we try to cope with the issue of internet shutdown by stop controlling the information online, But then if the government push or ask the intermediaries to cut on the access, is actually the same. The impact will be the same, because the end impact is there is a problem of freedom of expression, and also a problem of on privacy on this case. So this is the development, and we are still with more than 25 organizations across the global, including Article 19 here, and a lot of more. We are still continue to fight against this regulation that we thought this will be the challenge for Indonesia. Thank you, Gaya.
Thank you, Damar. Thank you. That was really helpful. Let me quickly hop over to Alan. Alan, I'm sorry we are running out of time, so if you could probably take a couple of minutes to give us your reflection or ask any specific questions before I move to the questions on the chat.
Thank you so much, Gaia, for this opportunity. So this was indeed an enlightening session with all the four, really good speakers out there. Which started out with Michael, who introduced us to the Bangladesh data protection, which he said is very much flawed, and the intermediary liability in India and China, and about censorship and how it versus the freedom of expression, and about the issues of data localization. And for when he said about data localization, something that quickly came into my mind was about the Aadhaar issue, wherein a lot of issues came up with the information of the people in India, citizens in India, going to servers outside India. So I think the problem with data localization is actually twofold, because there is one part of people who says that storing information outside India is a safer alternative, because it keeps the hands of those in power, away from the data. But there is another part of people who says that keeping the servers in India keeps it away from those entities which could actually access the data outside India or any other country for that matter, and they can arbitrarily use it. So there are two folds for that particular opinion, and about the local registration, which is work in progress, and about the challenges with implementation in big countries. So in a country like India, it is pretty much challenging, because we have a lot of infrastructure flows, and a lot of Southeast Asian countries like Bangladesh, Myanmar, and everything. We have a lot of limitations to how much infrastructure we can put forward in the coming years to actually make this all work. So that's another problem. We can make this work in parts. There are a lot of states in India which do commendable work in the field of disruptive technology and other forms of technology just coming up. But for a large scale implementation, it's still a challenge. And coming to Gaia, so she focused on Malaysian anti-fake law, which is actually a lot of arbitrary in nature, although it has a lot of essential factors, but it is not specific like most of the technology laws in many other countries, wherein the wider ambit of law makes it too vague for the people or the authorities to actually implement it. And most of the time it's become too arbitrary, curbing the actual right to freedom of expression, and giving an arbitrary power to the authorities in place to take up the matter and punish for innocuous, instances of, what they say as offenses. And most of the times in countries which have technology laws, they are giving priorities to the prosecution's arguments, like Gaia rightly pointed out, because even in India, we could see that, because if you, for instance, take other laws like the physical laws, the Indian Penal Code or the Criminal Procedure Code, we have a system which is accusatorial, which deems the offender not guilty unless proved. So in case of technology, it's a bit hard to actually prove that, because most of the time people are unaware of it, and there are not many experts who can actually deal with it. And when something like that comes up, even the punishments are twofold or even multifold in compared to the other offenses, and it's considered pretty much serious. And let me quickly summarize on our part. So he focused on how the Telegraph Act is still continued, which from the colonial times takes out, gives untraveled power to the authorities in place to take out, and about the internet shutdowns, which started with J&K and after Rajasthan, and about the important case of Anuradha Bisson and Shreya Shankar. And I think the courts have, traversed come a long way, because when we take the Indian courts, for instance, 5 years back and right now, I can see a certain change wherein the courts are actually accepting the technology, which was later seen in Puttaswamy case, and even in right now, where they, took out, where they set aside the decision which said that the cryptocurrencies were not a legal tender and all that. So, and Damar actually rightly pointed out the internet shutdowns in Indonesia, and about how he's fighting for, making Article 40 unconstitutional. I wish you all the best with that. And yeah, I think that will be all. Thank you so much.
Thank you. It's actually fantastic for the fellows of APrIGF to get involved in the sessions, and it's really great. So thanks, Alan, and I hope you will continue following developments around ICT regulation. That actually brings me to I'm going to ask 2 quick questions, and or rather quick responses to questions, because there are quite a few. Kaya, there were many pointed to you, right? Like, for instance, there were questions around whether there's a sunset clause, as in there's a time limit for the anti-fake news law. Does it end with the pandemic, or will the pandemic of anti-fake news laws continue? And then there were questions around what is the difference? Is there a difference between false news and fake news? Can you take that on? But also there was a question around, but isn't having fake news laws also good, because having a trusted, safe internet is good for all of us, right?
Okay, thank you. First one, there's a difference between false and fake, primarily because it's politicized, and I think that we need to be very careful in the kind of the lexicons and the language that we use. I think without a doubt, we have seen that the reference to fake is to try and capture everything, and that includes also inconvenient truth. So I would say that in many instances, the reference to fake, unfortunately triggered by Trump, has become very problematic because it covers a lot of types of content that are not defined specifically why they are problematic. So false would be, you would have to be able to demonstrate that that particular information is untrue or it's false. So I think that the reason why I raised that, and I think the question is good, is for us to be on alert and to make sure that we are checking the kind of languages that are being used, particularly by the authorities and the lawmakers in defining this. There is actually sentiments to support and this kind of anti-falsehoods or whatever you call it, because it is definitely an issue. But I think that that's where you have to have the kind of multi-stakeholder involvement in defining those legislations, right? And this is where I would say one of the ways to move forward is to have a much more open process in which the discussions about technology, hosting, platform cannot just be in the hands of legislators and the Attorney General's chambers, because they are so tech deaf, really, and blind. And I think that it has to open up, because one has to understand the different dynamics of information, who holds the information, who's actually liable. And I think that will be far more effective in curtailing what we do consider sometimes as problematic content, because it borders on hate speech, cyberbullying. There are other concerns as well. Disinformation is a problem, but it's actually not the problem in Malaysia, I would say. We have a very politicized environment, very race-based, ethnic-based. I would say disinformation is not top priority in this country. And I think we need to call it out for what it is. So I would focus more on equality, speech that is more positive rather than fake news. The sunset clause under the emergency ordinance is a good question, because we have no idea what happened to the ordinances and the emergency declaration, because they are playing it as a playground. And actually, there's no clarity in whether any of the ordinances since early this year, in fact, can still be used. There have been some questions about it, but to be very quick on that answer, we do not know whether the ordinances are off the book as of now, because it was never tabled in Parliament. And so there's a huge question mark around that. So that's the danger of having a emergency in the first place, and a parliamentary system that's actually been co-opted and messed up with in Malaysia.
Thanks, Gaia. That was super helpful. Apar and Damar, there are a couple of questions around internet shutdowns, and I wanted to ask you, this is not so much of a legal question, but is the alternative, or is the way to control internet shutdowns the move to community-based ISPs or community networks, or we call it different things. What do you think, Daman? What do you think, Apar?
My short comment on this is, as regulation as it presently exists, a license from the central government is necessary for provision of internet services. Thereby, even creating local mesh networks by itself will only at best help transfer information within that network who are connected to that mesh. It will not be a connection to the global internet by itself. Secondly, any provider within that mesh, if does connect to the global internet and has the technical facility of somehow linking that mesh with the global internet, they would be classified as a provider which is not licensed under the Telegraph Act. Penalties under the Telegraph Act by itself are not only civil in nature, they are criminal in nature and can lead to prosecution. Secondly, there is also another law in addition to the Telegraph Act, which is the Indian Wireless Telegraphs Act, which is there in terms of having licenses for any device which has a radio transmitter for receiving as well as transmission, and only has exemption notifications which permits us to possibly purchase our laptops and smartphones. Otherwise, even licenses for individual devices are the legal standard which has been exempted by government notification. Hence, given the level of legal regulation, technical solutions to overcome this problem by itself may be limited.
Thank you, Apar. Damar, actually, Apar makes a great point. Even if you have community networks, ultimately they'll have to follow the law as well. No? So I guess within a particular geographical location, I guess the wide mesh networks may still work. Can I ask you, Damar, do you feel like, are you hopeful? Are you hopeful rather that the courts will start providing greater clarity on digital rights in Indonesia generally?
Yeah, right now we are really depending on the decision of the court, especially the Constitutional Court, regarding the Article 40, point 2b about the excessive power by the government, especially the MICT, to terminate access. By that, then we have a greater power in civil society to do the next discussion about the how to do the proper way to do it in the human rights context, and also we want to challenge the government also to respect on the freedom of expression in a greater picture. In responding on the question about the community base, actually the technology is already here. We know the Open BTS, and it's already implemented also in several area in Indonesia, where the internet is actually still have a big digital gap. But I agree with Apar that the existing law in Indonesia, we have the telecom law that prohibit the operational of Open BTS. Since when it implemented, then the people who built the Open BTS will get a prosecution especially from the telco company. But I agree that this could be one of the solution regarding the internet shutdown. Although we have to think about the aspect of the law. We don't want to be we don't want our community people went to jail because of delivering a free internet access for the community.
Thank you, Damar. I don't know about internet shutdowns, but community networks will certainly help with democratizing internet infrastructure to start with. We only have 2 minutes, so let me get to Michael, but also to the other participants, to other panelists. What would you like to see happen in the next couple of years? Very quickly.
Well, certainly, I think the recommendations that APC, that SafeNet, that IFF, that all of the Article 19, the organizations that are presented here on the panel, I think in specific countries and in the region, our combined advocacy has put out many recommendations on these issues that, of course, I would like to see implemented. I mean, the changes I would like to see I would say in the short time frame is just, I mean, going to, you know, the work that all of these organizations have been doing. I mean, you know, again, just going back to my opening remarks, and in a very sort of you know, repetitive, you know, from the perspective of international human rights law. I mean, the changes that I would like to see is that any laws and policies that are in place are repealed or amended so that they are in line with states' obligations under the ICCPR and other, you know, relevant fundamental international human rights conventions, and in particular that they are, you know, respecting freedom of expression, assembly, association, and so forth, and that analysis is based on, again, three-part test and, you know, full open consultation with civil society.
Okay. Thank you, Michael. I really wish I could say, let's keep talking, but let's keep talking in the broader sense, but unfortunately not in this room before Kevin and others kick us out. But thank you so much. I mean, it was fantastic listening to all of you. And just the kind of knowledge that exists in the region is something that needs to be celebrated. And I wish us all the best in all of our fights and all of our battles for a better internet, for better legislation, for better judges, for women to be more in the judiciary, for women to be deciding the course of digital rights. I really wish us all the best, and I hope we can find a way to support each other. I'm sorry, participants, I actually wanted to ask all the panelists about positive developments as well. I know APAR has a few, I mean, the judgment in Indonesia is also one, but thank you so much. It was fantastic, and continue engaging with APrIGF, and we will see you soon. Bye.
Thank you so much, Gaia, for conducting this session. Thank you so much.
See you, Gaia. See you, Apar. Thank you, Michael.
Thank you so much, Gaia.
Thanks a lot, Alan, and all the best with everything you do in the future.
Thank you so much. Thank you so much.
Bye.
Everyone, nice to see everyone again.